Welcome back, future criminologists. In this video, we will be discussing crimes against national security and law of nations. By the way, if you are new to our channel, kindly consider subscribing. First of all, what do we mean by national security? National security was originally conceived as protection against military attack. However, in the modern times, national security is now widely understood to include also non-military dimensions, including the security from terrorism, economic security, energy security, environmental security, food security, cybersecurity, and many more. Ito yung kaligtasan ng isang bansa against military and non-military attacks. Ano ngayon ang crimes against national security? Crimes against national security include the so-called war crimes, and as an exemption, those committed both in times of war and in times of peace. These are crimes that attack the security of the country. In the Philippines, crimes against national security are embodied in Book 2, Title 1 of the Revised Penal Code as amended. Crimes against national security include 1. Treason, 2. Conspiracy and proposal to commit treason, 3. Misprision of treason, and 4. Espionage. Take note that rebellion is not a crime against national security, although in scope, magnitude, and purpose, it poses a danger to the security of the existing political order. Rebellion, under the Revised Penal Code, is classified as crimes against public order. I will discuss each of the crimes enumerated in a separate video, so stay tuned. How about law of nations? Law of nations basically means international law. Batas siya sa halos lahat ng bansa. Law of nations are body of rules that nations in the international community universally abide by or accede to, out of a sense of legal obligation and mutual concern. What are then the crimes against law of nations? Crimes against law of nations refer to crimes which all nations agree to punish. Crimes against the law of nations are punishable anywhere, being crimes against the family of nations. In the Philippines, crimes against law of nations are also embodied in Book 2, Title 1 of the Revised Penal Code as amended. Crimes against the law of nations include 1. Inciting to war and giving motives for reprisal, 2. Violation of neutrality, 3. Correspondence with hostile country, 4. Flight to enemy country, 5. Piracy and mutiny, and 6. Qualified piracy and mutiny. I will discuss each crime in a separate videos. Now let us discuss their common denominator. These crimes against national security and law of nations, can be prosecuted even if the criminal act or acts were committed outside the Philippine territorial jurisdiction. This is one of the instances where the Revised Penal Code may be given extraterritorial application under Article 2, Paragraph 5 thereof. Halimbawa, si A, Filipino citizen, pero nasa ibang bansa siya nung ginawa niya yung crime na treason. Ngayon, pwede siyang kasuhan ng treason dito sa Pilipinas, kahit ginawa niya yung krimen sa labas ng bansa. Take note, however, prosecution can proceed only if the offender is within the Philippine territory or brought to the Philippines pursuant to an extradition treaty. Umuwi muna siya or pauwiin muna siya para mag-prosper yung kaso. So saan naman sila nagkaiba? In crimes against national security, it can be tried only in the Philippines, as there is a need to bring the offender here before he can be made to suffer the consequences of the law. So kahit ginawa niya yung crime sa ibang bansa, dito siya sa Pilipinas kakasuhan. Hindi siya pwedeng kasuhan sa ibang bansa. In the case of crimes against the law of nations, the offender can be prosecuted wherever he may be found because the crimes are regarded as committed against humanity in general. Kung ginawa niya yung crime sa ibang bansa, pwede siyang kasuhan doon based on the foreign law. Kung hindi naman siya makakasuhan doon, pwede siyang kasuhan dito based on our laws. Thank you for watching. If you like this video, don't forget to share it and to subscribe.